Welcome to valuationpodcast.com, a podcast and video series about all things related to business and valuation. My name is Melissa Gragg, and I'm a financial mediator and business valuation expert. And today we are with Lisa Zeiderman. Lisa's a managing partner at Miller Zeidman, LLP. She's a matrimonial attorney, family lawyer, and CFL, which she'll tell you more about, and a certified divorce financial analyst, which some people know about. She also regularly handles complex financial and custody divorce matters for high net worth individuals. So this episode is going to be about the current state of divorce in New York, and kind of the beginning part of it. We're going to focus on some of the things that business owners should understand, professionals, people that are handling divorce. There are nuances. And then at the end, we're going to talk about some pro se. So that's where you're representing yourself or you're doing some of this work on your own, which is how you kind of cut some of the costs. So welcome, Lisa. How are you?
I'm good. How are you?
Oh, this is amazing. And you are coming to us live from another country. So we appreciate you.
I
And
am.
busy traveling the world. We love that. So I wanted to start off just by kind of big topic things that if you're getting divorced in New York, and the reason why we're starting here is because I actually talked to you about some of these things, and I was a little surprised about some of them. So I think just general top couple things that if I'm a business owner and I'm getting divorced in New York, what should I be aware of? What are some interesting things that could kind of, get me caught up, or, what are unique to New York?
So I think the first thing that you should understand is that your business is going to be subject to what we call equitable distribution, which is a distribution of the value of the business. So you, as the title owner of the business, are likely going to keep your business. And what's going to happen is it's going to be valued by a forensic accounting firm, likely, who will come in and provide a value. There'll either be a neutral forensic accounting firm, perhaps someone that both your attorney and your spouse's attorney choose together, or someone that a court appoints if you're in court, or you have the choice most times to have your own expert do the valuation, but then expect that you may have, an expert from your spouse as well. I think that the other thing that you need to know is that in New York, it is rare, and I mean really rare, that after the valuation, when you're dividing up a business asset, that your spouse will receive 50% of the value. That is a very rare occurrence. And the reasoning is that the person who actually is the title owner to the business is usually doing most of the work in the business, making the biggest contribution to the business. And so what's going to happen is your spouse may end up with a valuation and then some sort of a percentage, almost always likely less than 50%. But again, depending upon the circumstances in the case, the length of the marriage, for example, your spouse's contribution to the business, was your spouse actually working in the business, that will drive the percentage up. Other things that your spouse may have done for the business, contributing money, contributing separate property funds, all of those things will be factors. I think what is also surprising for a lot of business owners is how in-depth the discovery becomes. And when I say the discovery, the documentation that you as the business owner will likely have to provide to the quote expert or your spouse's attorney. And this is a very important piece because I think that people aren't used to giving over their documentation for their businesses. And they sometimes find it very offensive, very upsetting. Somebody is going through their general ledgers. Somebody is going to be looking at the tax returns. All of this information is going to be important. What expenses are you putting through the business? Somebody may say, it wasn't right that you paid your mortgage from your business, for example. And so those kinds of expenses become normalized. And when you're doing the value, and they get added back as if they were income. And that's another piece that's important. So I think that there are some surprises for business owners. I think that there are ways, as you're heading into marriage, perhaps to prevent some of this. But I think as a business owner, if you're married and you're going through a divorce, you have to expect that your business is going to be valued and that you are going to be actually handing over discovery to your spouse's attorney and evaluator.
Well, and I thought it was interesting because you had said, because normally that type of analysis of the business to determine if it's, 30, 40, 50% of the business is normally what we see when we're tracing separate assets. And that's what I was asking you. I was like, okay, well, hold on. So what if you say that it's separate? Is that still a situation then that you can claim separate and you have to prove it, or where's the burden of proof there?
Great question. So in New York, the law presumes that if a business is created during the marriage, first of all, it is marital property. There's a presumption. Anything actually that is created during a marriage is going to be marital property. If your business actually existed, meaning you had your business interest or your business prior to the marriage, then that may be separate property. And what also may be is that the appreciation of the business during the marriage may become the marital property. Okay. So what you're going to want to do in the case of you've had the business, prior to the marriage, perhaps it's a family business even, and we can talk about that because that adds some complexity. But let's just say you got married, you had a great business, and now you are married for 10 years, 20 years, whatever it is. And your business has increased in value during the marriage. You had it before the marriage, but now it's increased in value. Well, what's going to happen is there's still going to be a valuation. It's going to be a valuation as of the date of the marriage. That will be your separate property, right? So that's your separate property. And then as of the date, usually, of the commencement of the action, the divorce action. So maybe when you filed a summons, or your spouse filed a summons, that particular date is very important. And you're going to actually see what was the appreciation, if any, during the marriage. And then that becomes the essentially the target, right, for a distribution. Very important that those two pieces are done actually and valued. And then that's your separate property, the property that you had prior to the marriage. But it is going to be on you to actually produce the documents so that the valuations can take place. And it is important to have your records. So a lot of times it's the most difficult part of this. You don't have your records. And then what do? And so it is tracing. And it is tracing of your separate property and making sure that you've done that, and then making sure that obviously the appreciation is valued.
Well, and I know that some states look at appreciation in the business as different than income in the business. Like we'll have retained earnings, or we'll have, they kept all that money in the business kind of situation and they kept it from me. And so do you have issues where you're having to look at that separate appreciation, or that marital appreciation or income? How do we deal with that?
So income is one part of this, and you're going to look at income for purposes of spousal support, child support, etc. But you're still going to be looking at the appreciation, because the appreciation is your equitable distribution, right? That's going to be, frankly, your lump sum payment that you're going to be paying out. Maybe it's going to be some percentage. Usually, I'm going to say that when it concerns appreciation, as opposed to a business that is just created during the marriage, the percentages tend to be less that your spouse is going to get. So that's also important. Mm-hmm. We've seen cases where maybe it's 10%, 20%. Maybe it's a long-term marriage, 25%, but it's a very different situation than when it was created during the marriage. And go ahead.
Well, I'm wondering if people proactively value their businesses at the date of marriage in order to preserve it.
It's such a good question. So I would say, that it's great if you have that valuation. Sometimes if you can do that, that's great, because then you have it. And you can go one step further. You can create a prenuptial agreement. And you can actually, in your prenuptial agreement in New York, you could delineate your business as your own. You can delineate the business that you created prior to marriage. And by the way, you can delineate the appreciation as your separate property too. And that's why it's so important for business owners to consider prenuptial agreements. If you are a business owner and you are getting married, you really should consider a prenuptial agreement. And if you're a business owner and you're already married in New York, you might consider a postnuptial agreement.
Well, the other thing, because you brought it up, is that we typically will see this in family businesses that are family held. They will sometimes have it in trust or very well protected, but there's also some situations where it's not as protected. And what I see that is happening is there are gifts that are made, but there's not like a gift tax return filed, or there's not actually any proof that that gift was made, and that wouldn't have cost that much to do that gift tax return, and it would have kind of preserved that intent in some cases. So what would you say to somebody who's kind of in that situation where it's a family business and like they really don't have control? I've seen very powerful matriarchs and patriarchs that don't allow the income to go out to the family, and so it looks like it's being held in there.
It's also true. And I'm going to say this, I have friends, many friends actually, who have businesses, and they've started to give stock in the businesses to their married children. And I sometimes have to bite my tongue and say, you're giving this stock to your married children, but there's not necessarily a prenuptial agreement. Maybe you're not filing a gift tax return. Maybe, you're not thinking about the fact that this gift hasn't been documented with a gift tax return. And so, and by the way, and your adult child may be working in the business. And then it becomes a very big question. Well, was it a gift, or did the adult child earn that stock in that business, right? And if that adult child has been working in the business and now you are giving that person stock, well, maybe it wasn't really a gift. Maybe it was earned. And if it was earned during the marriage, then your spouse is going to say it's a marital asset. You got the stock during the marriage. You were given the business during the marriage. You worked in the business during the marriage. And now, as a result of your hard work, and my contribution, if I was the spouse, right? You now have a business. And so it wasn't a gift, is what you would argue as the spouse. And now I want my percentage. And this is absolutely an issue that comes up so often. And I think that business owners don't always think about these things, right? They're just trying to do their business.
Yeah.
And they're not thinking about, the fact that they're giving away the stock or they're receiving it. How am I going to protect this family business? Some of these businesses may have been generation after generation, and now they're up for grabs. And by the way, when it goes to the spouse, when the value goes to the spouse, that those lump sums will go to that spouse's spouse next. Right. So it's really important to think about all these things as a business owner.
Well, and I think what you're talking about in some other states, we call marital contribution, where you're looking at, what were the efforts in the marriage to benefit the business? And then typically, are you fairly compensated for that? And so are you seeing kind of them having to prove the compensation levels, or is that kind of an easier assumption? Like where are you seeing valuation people really having to either prove, some issue in the process?
So in New York, what we use our valuators for is to obtain the value. It's then up to the lawyers to deal with proving what the percentage should be. So, right. So if I'm representing the spouse with the business, the titled spouse, then my goal usually is to show how little the other spouse has contributed and how much my client would have contributed to the business. So that, my client would have gone to the business every day, worked these hours, put in this time, all of those things, met with clients, traveled, etc. Now, if I'm representing the non-titled spouse, I'm going to be talking about all the other contributions. The fact that, if the business owner was traveling, if the business owner was going to work every day, if there were children of the marriage, if if things had to get done, even like picking up the dry cleaning, cooking the meals, doing all the taking care of the children so that somebody could focus on their business, that is a contribution. And by the way, if I worked in the business as the non-titled spouse, if I was the bookkeeper, or I was responsible for running the day-to-day administration, or I was doing the sales out there and the marketing, or I was building the website, or visiting with the customers, or socializing with the clients or customers, or the partners in the business. All of these are contributions.
Mm-hmm.
And so the question is now not up to the valuator, because the valuator has come up with a number.
Okay.
And now it is up for the attorneys to be making their arguments based upon the facts of the case as to what each party's contributions were to this business. And those are very fact-intensive situations where you really need to be speaking to your clients, be understanding the day-to-day, how the business got started, what was the seed money for the business, how did it grow, who was doing what.
Yeah, well, and it's really kind of understanding what's under the purview of the financial expert and what, because this goes back to like separate and marital. Separate and marital is a legal construct, but we're coming in and maybe quantifying some sort of tracing. We also see it in fraud. And so we're not coming in to say there's fraud and they stole the money. We're just saying it was here and now it's gone. And what happened to it, and does the facts support that it went somewhere? So I mean, those are kind of things that I think are typical misnomers. I think another thing that's just a random thing that I had learned recently was when people ask for how do you file for divorce in New York, and is a attorney required? I thought that this had an interesting answer.
So an attorney is not required. Look, do I think that an attorney should be retained? I do. I think that we see so many people who try to take that shortcut and then come to us in the middle or the end or after it's done, and it's just, frankly, just a hot mess. So I would say that your best bet is to retain an attorney who is familiar with the law, familiar with how the court system works, familiar with what's going to be, negotiated, what the parameters are, so that you're not taking positions that don't make any sense. That being said, in New York, you are permitted to be a pro se litigant, which means you can operate pro se. You can also negotiate your own agreement. So if you want to go to the negotiating table and you want to negotiate your own divorce agreement, you can do so. Again, I don't think it's advisable, particularly if your spouse has an attorney, that you're going to be put, that you're going to put yourself in that position. I think it's much smarter and frankly makes much more sense to have someone who can advocate for you. But can you do it? You absolutely can do it.
Well, and I think that most people have this perception that when, like I've been thinking about getting divorced for like 2 years, I'm just really frustrated. All of a sudden we had, this crazy event happen and I'm done. Right. And they're just like, I'm going and I'm filing on Monday. And I think that, if you could just explain just maybe a little bit that it's not just going in and like filling out your name and your address and saying, okay, I put a pin in it, I'm filing today. And then they say, okay, now do all of these things. It's sort of like you have to do all of these things and then bring all of that to this filing. But can you explain it maybe in a better way from a legal perspective?
Sure. So I think you have to look at it as a big box, right? And the first thing you're going to put in your big box is you're going to file for divorce, and you're going to file what's called a summons and a complaint. And then you're going to serve them, and into your big box goes what's called an affidavit of service, meaning your spouse has been served with divorce papers. And now you have an affidavit stating that they have been served. You're not going to serve it yourself, by the way. You have to actually get somebody who can serve it, who is of the age that is legal, et cetera, to do that. Then after that, you're going to actually want to fill out, both of you, what's called a statement of net worth. And that is going to have all of your expenses And it also will list all the assets and liabilities. And you're going to be swearing to it. So it needs to be accurate. So, for example, we're in 2024. I usually tell people to look at 2023 unless 2024 was a complete year, because that gives them a whole year, 2023, for example, of their expenses. And you're going to fill that all out. Now you have your burn rate and you have your assets and your liabilities. Net worth statements go in your box. Now comes the backup information. Somebody's going to be asking for backup information because it's a divorce. Sometimes people don't trust each other. They may not trust that the assets and liabilities listed are accurate, or that the expenses aren't inflated or deflated, or that the income is correct. All of those things, right? So they're going to ask for backup information, goes into the box, right? And by the way, people are reading this information that goes into the box, and they probably are going to ask for further information. And then hopefully, if things go well, there's going to be some settlement proposals that go back and forth and a negotiation. If things don't go as well or as smoothly, then there may be a court appearance, your first court appearance. And so that's going to go into the box, and that's going to have all sorts of deadlines and discovery demands and maybe depositions where people are asked under oath.
Okay, hold on. Okay. First of all, like, I'm a business owner and I'm giving you my tax return and I'm giving you my financial statements, my QuickBooks, my general ledger, and hold on. And that is going in the box
Yep.
but the people can't see that, right?
Well, when you say people, so your spouse is going to see it. Your
Okay.
spouse's accounting firm is going to see it. Your spouse's lawyer is going to see it. But no, and by the way, a judge may see it, right?
Okay.
A judge may see it because at some point it may be evidence in your case. And so all of that is going to be seen by the people that I just actually named, right? But it isn't going to be spread, okay, throughout the internet. And by the way, as a business owner, you may want to have a confidentiality agreement. Perhaps there are trademarks, trade secrets, things that you don't want out there. You don't trust your spouse to keep, things under wraps. So there may be confidentiality agreements also exchanged so that information is kept not only by the attorney and your spouse and the accounting firm, but they are kept confidential. So that's important also. So that is a very big possibility, and you need to make sure, if you feel like the information needs to be confidential, that you actually get a confidentiality agreement drafted. There should be no reason why someone shouldn't have a confidentiality agreement if they need to have it.
Yeah. And I think some business owners are surprised that their financial data is going to go to so many places, because they typically are like, can I have my current accountant or CPA just do the valuation? Like they know, I mean, come on, Lisa. They know my books, they know my financials. It's going to be a lot easier if we just have them do it.
Wow, I could have that conversation so many times in my office. And that's not happening. Okay. I'll just say it the way I say it in my office. That isn't happening, right? Because first of all, is your spouse really going to trust your accountant, okay, who relies on your business to feed their families, to do the valuation, right? And second of all, are they really equipped to do those types of valuations? There are probably, I don't know, maybe 10 firms that are out there in New York that are used very, very often, who really understand what the expectation is in how to present a report, how to testify about a report, how to help during settlement, and even to work with the other expert. They know each other. And so that helps sometimes to negotiate agreements. So no, that's not going to happen. The accounting firm that you use on a everyday basis, they're not going to be doing the valuation. Not happening.
Well, and the interesting part is, I think that you have to be aware of is if they're doing your personal tax returns too, the both of you are the client. So like your spouse is also the client, and your spouse could easily say, hey, give me all the work that you've done because it's for me. Now, that puts basically the CPA in an area that's like a conflict of interest, which most CPAs would be like, well, if I don't do the audit, I'm not really conflicted. And I think it's a discussion amongst them. Obviously, we're hearing from an attorney that it's probably not the best idea. But I think it really goes back down to their background to make sure. Another thing that I think that business owners, you know, I think business owners are hesitant to get divorced because they don't know how much of their business, like they don't know how much the business is going to be valued. They're very concerned because they always think pie in the sky of what their business is worth, And so the other thing, though, besides the business value is alimony. And I think
So
that, yeah, is there some way that that is calculated?
So there is, but I want to say
Yeah,
something
yeah.
because you just made such a good point, Melissa, and I want to go back to it. One of the documents that is so often used by attorneys are financial statements. And business owners often submit financial statements to banks to get loans, to get capital for their businesses. And it is really important to make sure that those financial statements are accurate, that they are not inflated, because I can tell you that those are what we call admissions. You put in a financial statement and you've asked a federally chartered bank to give you a loan based upon that financial statement. Well, you could be sure if you've inflated it, you have a problem, because your spouse's attorney is going to turn up with those financial statements. They're going to subpoena them from the banks. They're going to ask for them in discovery, and those numbers are going to be used. And so just as it's important to be honest about your income, your expenses, it's important to be honest about your financial statements. Even when you go to lease your car, don't inflate your income. Okay, don't inflate your business evaluation, because all of those
For
things that
every personal loan, like literally the financial statements could be the linchpin that really says how different it is. It's also in operating agreements. It's also in buy-sell agreements that you agree like to this astronomical price to exchange, to buy between partners. And you're like, oh, we would never do that. But you did. You actually negotiated that. That's probably what you did think it was worth at the time because you negotiated it. And these things are indicators. The other thing is bank statements. Bank statements and credit card statements. I will say, now, let's go back to the one you just said, though. When they get a financial statement, the most part, what the client's going to say is, well, let's go get them on bank fraud.
That's
And
right. And look, it doesn't help to go after your spouse who has the business, okay, to try to get them on bank fraud. That's not really helpful, okay, because you don't want to kill the golden goose either. But it certainly is, as I said, it's an admission against interest. And it certainly is going to be a document that they're going to utilize in depositions, in discovery, in court papers, in all of those. And what are you going to say? I lied? I'm not really sure what you say, because that is a credibility issue too. So I think that people have to think about what they're doing when they're in business. And again, it goes to, I'm going to go back to it because I think it's so important. Prenuptial agreements, right? They are so important for business owners and families who have businesses that they're passing on. They should encourage their adult children to think about these prenuptial agreements, because they really are important. It's not just you. It's not just you who is going to be exposed. It's your family too. Those family businesses.
Well, and I think that, like after everybody files and you have some suspicion that they're doing something in the business and you start issuing subpoenas out, and because a lot of times no one's going to stop until that discovery gets, like you get the subpoenas, you have how many ever weeks to return them. And then you start digging through those bank statements and those credit card statements. And I think it's fascinating because we're such patterned individuals. and it's most of the time we're like, oh, you're never going to find what they did. Like they moved so much money. They're so good at what they do. You'll never going to find it. It's all in the records. It's all like clear as day where you had, lunch with your girlfriend at 12 o'clock on every Thursday. Like it's clear as day, your movements through the business as well from a financial standpoint. So if you think that you're going to be like, oh my gosh, it's 9/11/2024 and I'm going to get divorced today, right? And if you think that they're not going and well, wait a second, I can't get divorced today. I got to plan ahead. Okay. So let's start being clean on everything right now. Like they're going to find the hidden credit card. Like they're going to find the hidden, and like, let's say I hide it. Lisa, I hide that account. I hide that credit card. No one found it. I got away scot-free. Like, am I good? Am I off the hook?
So the answer is, if everybody has a signed agreement and it was missed, you may be off the hook. You may get away with it. I mean, it's not impossible. Maybe there was cash taken, maybe you were paid in cash and maybe you were able to hide your cash. Look, we're not all flawless, right? So I'm going to say you may get away with it, but the problem is if you don't get away with it, if you hid that one credit card and because you were putting your expenses on for your boyfriend or your girlfriend or whatever it is, right? If you hid that one account, then everything else starts to be called into question. And then you've just bought yourself a very expensive divorce. And you've also bought yourself a long divorce, right? Because you could be sure that the attorney for your spouse is going to be going through everything and double checking it and making sure. And there's going to be an expert who's going to look even more closely. And so it really is, I hate to say it, it's really important to be credible and to be honest, because if you aren't turning over the documents, if you're hiding stuff, it's going to make it much more difficult. It really is.
Yeah. I mean, as the business owner, you're going to be the person that they blame everything on, whether they're the female or the male, because that's where most of the money is going to go through. That's where most of the money is being created. And that's where all the eyes are going to be. And you've also had these conversations of like, honey, we're going to make millions and this is worth so much, and so then it comes down to kind of going back to the two things about alimony and adultery, because like this is where we would see like some states don't care about this. Does New York care about adultery?
So New York only cares about adultery to the extent that you have spent marital monies on someone who you're having a relationship with outside the marriage. That is the extent of what New York really cares about in terms of the finances. Well, there may be other things in terms of custody that New York may care about, but for the financial issues, it's really, was there a wasteful dissipation, that's what we call it, of marital assets, where these marital assets used, for example, for someone outside the marriage to travel, to buy gifts, to take them out to dinner, to do all of these things, and that is, and then there's going to be a calculation done so that it's quantifiable, and then at least half of that is going to likely go back into the marital pot, right? Or the whole thing will go back in the marital pot and then it'll be equitably divided as if you didn't spend it. So we certainly do care about it and we do try to quantify it and we do look for it. And, years ago I had a client who was sure that her spouse was not having any affair. And I remember her coming to me and saying this, and I was listening to the stories and I'm like, this doesn't sound right. And 2 years later, the person came back to me and she had found all of this documentation, and all of a sudden it became the reality, right? And we quantified millions of dollars that were spent. I mean, gifts and travel and all sorts of expenses, and it went back into the marital pot. Mm-hmm. And then, and so as if it was there, it was then divided up again, right? So it is really again, you're
And I've seen
going to
some
be.
of this in gifts, like I'll see it in gifts as well if they've gifted away. But I also see, I mean, I'm typically recommending that unless you find some big pops of money that are going out, that it's not always the best analysis to pay for because it's hard to quantify. It costs a lot of money. And if you don't find enough and it's hard to prove, right? Then it's sometimes not the best cost benefit. Whereas if you're looking at alimony, that's going to be on a going forward basis for, maybe a certain amount of time. If you're looking at some of these a business valuation, there's more flux in a business valuation than there could be in $100 dinners left and right, because people are going to hide this. Like they're going to try to make you look for it and hide it in various accounts at places that you hopefully already went, so that it's not so obvious. But
I agree with you. And I think that you really have to look at whether it pays or not. Sometimes it does. Okay. Sometimes it
yeah,
does. Most times you're right. It doesn't. And so if it's part of the bigger analysis and it happens to come, as part of it, fine. Sometimes it's good to just settle on a number. Like we know that, you were seeing somebody outside the marriage. Let's just settle on a number and be done with that portion of it. And let's move on. And you've asked about alimony, and it's such, look, I'm going to say this. In New York, I think that alimony is difficult sometimes for people who have long-term marriages. It never, I shouldn't say it never, but it rarely gets you to the place that your lifestyle was entirely, right? So you have to expect that although lifestyle is one of the factors that you look at when you determine alimony, there are a lot of other factors, and it doesn't go on forever. It's rarely lifetime. So for example, if you're married up to 15 years, it's going to be 15 to 30% of the length of the marriage. If you're married longer than 15 years, like up to 20 years, then it's going to be, let's say, 30 to 40% of the marriage. And then over 20 years, then you're looking at 35 to 50% of the length of the marriage. But if you think about it, right, that's still not that long. And
right.
So I think particularly for and I'm going to say this, it's a little bit gender specific to some degree because we see it so much more for women, but for women who have remained at home and have been taking care of the children, and now it's, a 25-year marriage, and it's very difficult for them because no matter what, they don't get that benefit of that, trajectory of their income going way up, right, over the years.
Right.
And so they, no matter how much alimony we get for them, it's still not probably enough for them. But there's a bunch of factors that are looked at, and one of them is, of course, the length of the marriage, as we just talked about, and the age and the health of the parties, each of the parties. And it's important because if somebody is 70 years old and you're getting divorced from them, they're not going to work for another 20 years, right? So we've got to be somewhat realistic about this, all right? And, then they look at the present or future earning capacity of each of the parties, which is also important. What is the educational background? How much could you earn if you haven't been in the workforce? They may impute income, right? Someone may impute income to the non-working spouse and say you could earn such and such. A vocational analysis may get done so that they actually can figure out what is the income that you would likely earn if you were out there. Did you take care of the children? What was your lifestyle? What was your educational background? Was there a wasteful dissipation of assets? Was the domestic violence that prevented you from going out? Was there a premarital joint household? So maybe actually you got married, and you were only married 5 years, but you lived together for 15. Okay. And maybe you had a kid. Okay. During that first 15, they're going to look at that as well. Certainly the fact that health insurance has to now be purchased by a party when maybe it was covered before. So that will be factored into the calculations. Whether there was care for children or stepchildren of the marriage, of the, maybe you cared for your spouse's stepchildren. That's something to be considered. Tax consequences. Now, that's important. And basically, the fact that you did not get that opportunity to work outside the home because you were taking care of children, they will look at that. But at the end of the day, a lot of it is about lifestyle and about the income of the other person, right? And what you are able to earn out there. And then there is a calculation. We have what's called statutory guidelines. So there's a statutory cap, which is then the calculations are made, but then the courts and your negotiations can go further than that because of all these factors that I just listed. Mm-hmm. So those are all really important considerations, particularly in high net worth cases, to consider, because your lifestyle, your burn rate may be very high, and the incomes may be high.
Well, and it was interesting because I think yesterday I was talking to somebody about rehabilitative maintenance, and I was like, the intent of maintenance is to rehabilitate and to get you to a place where then you can support yourself. And I said, not what we see in the movies, which is get you to the lifestyle that you've grown accustomed to. And they were like, I have never heard of this term. And I was like, I know most people haven't. And I think that is some of the piece of it that, are you seeing any lump sum payouts for maintenance or anything like that to kind of settle everything at what? Because I don't think people even understand then what that concept is.
It's such a good question. So we are seeing lump sum payouts where, clients are either wanting to just be done and pay it out. We'll talk about that in a second because it's not necessarily a good idea. Mm-hmm. Or somebody's receiving a lump sum payout, which is terrific because, you're not having to chase it basically every month. You don't have to worry about somebody going in because they are modifying it. Maybe they become disabled. Maybe their health situation has changed, or they have no job anymore, or their business is collapsed, or any of those things. So a lump sum payout is great. It's also great because if you're considering getting remarried, then having a lump sum payout is fabulous because you've now received the money in hand, and you don't have to worry about your maintenance actually ending upon your remarriage, which is often the case where it will end upon the remarriage. So you also don't have to worry about life insurance securing the maintenance payouts because you've got your money in hand. Yeah. But if you are the payor, I'm going to say, okay, you're unless you're getting a nice deep discount, I don't know that it's really a smart idea. Yes, psychologically, you may not like paying it every month. It may remind you that you are married to this person, that you have to make a payout. But, if your spouse does get remarried, then your payout usually ends. If someone dies, your payout has ended, right? You may have life insurance if it was you, the payor. So you might have to carry life insurance. But you also have to consider that maybe you could have earned income on that payout. Mm-hmm. And so you've given that away too. You might have been able to use that to invest in something, and you might have actually increased your wealth because of that. So there's a lot of considerations when you're actually the payor. If you're the payee, getting it is really is a big bonus.
The other thing that I think I see a lot of times is that, primarily we see one spouse wants to stay in the house, one spouse, one of the things is that they may not be able to afford to stay in the house. I mean, that I think more often than not, we see situations where the spouse that wants to stay in the house cannot afford it, or if there was separate monies that went into buying that house. Are there any unique things around houses that you have to deal with in the state of New York?
Well, you have to usually deal with the fact if there's a mortgage, you're going to end up having to get the other person, if you're buying the other person out, off the mortgage because they're not going to want to stay on the mortgage. And right now, although interest rates are starting to drop, what we saw in the last year is because interest rates were so high, people didn't want to refinance their homes, right? And then they didn't want to have to take their spouse off the mortgage because the rate at which they were refinancing was so high, and they were going to have to pay so much that, to your point, they couldn't necessarily afford to stay in the house. And so we had a lot of creative plans in terms of people would be willing to stay on the mortgage, but then, their alimony decreased significantly, or their child support decreased significantly, or there were a lot of deals that were cut, so that someone was not so disadvantaged if they were staying on the mortgage, because staying on may mean that you can't buy your own new home because you've got this debt.
Right.
And so that I think is really important. I also think that it's sometimes, and right now is one of them, it's very hard sometimes to find housing so that your children can remain in the same school district. And so it becomes very difficult. And both parties may want their children to remain in the school district. And it may be that there's just no housing to find, which is the case in some places of New York right now, like Westchester County, for example. It is so difficult to find homes, and they're on the market for a day and then they're gone.
Mm-hmm.
So
Mm-hmm.
I think that a lot of this is about timing, and about flexibility. And also there's a lot of psychological parts to this about wanting to stay in the house.
Well, and I see, I see one of the biggest manipulations when there is a business involved and a house involved is that everybody's trying to say, okay, what's the equity in the house? Great. That's what the business equity is. Oh, and then you keep the house. Oh, and take that mortgage. You're going to have to take that mortgage. And I'm going to just keep that business, and you don't need to know any more about it. And I think that's where we get into, and we get so emotionally attached to that house that we're just like, okay, I mean, they said that's what it's worth, so I guess that's what it is. I mean, do you see any other places where we see the biggest, where they're just basically making up numbers?
Well, so that trade, right,
Yeah.
sometimes is about retirement accounts also. But
Oh,
you're
yeah.
100% right. I mean, retirement accounts and businesses and homes and businesses and any place else that we can just kind of say, oh, it's a wash. Let's just do that. And look, as an attorney, I'm going to say it's better to know what the real numbers are. But people sometimes are willing to cut those deals and willing to move on. And sometimes they say, you know what, it's enough. And they are the clients, they can make that decision. But sometimes they want to know
Yeah.
what is the fair number here. And I think the other piece of it is, remember, right? So retirement accounts are almost always split on a 50-50 basis, where the business value, as we talked about at the very beginning of this, right? That's not a 50-50 usually.
Right.
So, and retirement accounts are taxable usually, unless they're in Roth IRAs. Okay. So and there may be penalties in terms of taking them out early. So it's not all dollars for dollars here. You can't just trade one for the other necessarily. And you have to look at that. And so that's my CDFA hat, right? Certified
Right.
Divorce Financial Analyst. You have to look at what is the bigger picture here. What are the tax ramifications? What are all of the pieces? And it's not necessarily all dollar for dollar. They're not all equal. They're not created equal.
No, and I think that that's the biggest piece of it, is trying to understand, a lot of times I think that people are saying, well, I don't think that that's the value, but I don't know if I want to pay for somebody to get it valued. And, I think that for the most part, it was my understanding that if an attorney says, oh yeah, go ahead and don't value that, then that's a little bit towards the malpractice side of things. And they really need, they would have to just caveat and say, well, you can do whatever you want, but I'm not recommending that. But I think a lot of that is happening behind closed doors of like, well, that seems like reasonable enough. And the problem is, you have a business that's an income producing asset, and you have a piece of property, you have like a house that is an income consuming. And so it's not making any money, it's actually consuming. And if it's a house that we can't necessarily afford to stay in, it's going to consume at a double rate. Right. And so this person goes off to continue to make money, and this person is now consuming money, and we don't think we got the fair shake. And so I think that that's another issue that maybe we see this like comparing income producing assets and non-income, like exchange a house for a retirement. That makes sense, right? They're both just kind of stagnant things, right? But
So
yeah,
yes and no, right? Be careful because people need to be careful about that because the house, unless there's a capital gain, that's dollars, and they're not going to be taxable. Okay, you're going to equitably divide the proceeds if you sell it, right? And you might have that $500,000 deduction for capital gains before you have capital gains taxes applied, and so. But the retirement account may be taxable when you take it out, and so when people say to me, well, I've got 500,000 in equity and I've got 500,000 in the retirement accounts, it's not the same.
Yeah.
Right. And so it's really important that that people think about this and make sure that it's apples to apples, that they're actually dividing. And and so that's why I think it's really important to work with an attorney and not to necessarily do this on your own because they're used to doing this. Attorneys are used to thinking about this.
How many attorneys have a CDFA, right?
Correct, but you don't necessarily need a CDFA for an attorney to know that a retirement account is going to be taxable unless it's a Roth. Okay, so I'm not telling you that some attorneys, all attorneys know this. Okay,
right.
But certainly they should know it, or
Sure.
they should be working with an accounting firm, and certainly it's something that is important to know, and those dividing those assets. That's really why you don't necessarily want to be that pro se litigant, because you may be that pro se litigant who's not thinking about all these things. And look, it's a stressful part of life to get through divorce, right? And you might you might be saying to yourself, let me just get it done. Let me just get it done. I got to get out of here. And that's not necessarily the best route.
Right. And I have one more, or maybe a couple more questions, but one good question from a business perspective is that, like, if I have a business, sometimes I'm also going to have, so I've dealt with that now. And now I have maybe a pension or a profit sharing, or in some cases, you may be an executive in a business and you're getting stocks or options, or you're investing in businesses, private equity and stuff like that. And you have these like little, like, oh, I have 3 shares in this thing that's a startup that we put some money into. Are you seeing all of these also have to be valued, or, are you dealing with these issues?
So we deal with all of these issues that you just
Okay.
listed. So I'm going to say this. Sometimes they do need to be valued. So
Okay.
I'll go through them one by one, really. So if you have restricted stock units, the first question that has to be asked is, did you get restricted stock units for past performance or future performance? And by the way, we could do this I've given lectures on this particular issue.
But I think like it basically was it created before the marriage or after the marriage? Like a vesting, like understanding vesting is a big deal.
Yes.
Right?
So is it, first of all, did they vest? And if they vested during the marriage, then likely it's going to be marital property and that's the end of it, right? But some of them may be vesting over time, right? So there may be a cliff vest like in 3 or 4 years. There could be some sort of a tranche situation where you're vesting every year a certain amount of them, but you've received them. So let's just say you have 1,000 restricted stock units and they're going to vest over the next 4 years. And the reason that you got the reason you got them was to keep you at the company, right? Because makes you want to stay at the company to get those vested shares. They're going to vest and I'm going to, have all that money. If that's true, in New York, we use what's called a De Jesus formula. And we probably could do a whole show about this particular situation, but it is essentially a fractional formula, and there is a way to figure this out. And some of this might be your separate property, and some of this might be marital property. You might have gotten them, by the way, as a bonus for past performance. So maybe you got them, I'll just say, let's say we're in 2024, maybe in 2025, you're going to get a whole bunch of these restricted stock units, but it was for past performance for your 2024 work. That is probably not going to be subject to the De Jesus formula. They may all be marital. And so it may be a question of when you file, what part of the year you file. So we'll put that to the side. It's a great topic, and it's complex. As to pensions, as to pensions, not 401ks, but real pensions, those can be valued if you want to trade them for something else, right? So we could figure out what the value of them is. Somebody, actually an actuary, usually we hire an actuary to do this, and they come up with a lump sum that they calculate as to what that pension is worth, and then you can trade it for something else. Or you can simply divide it using a formula at the time that there's going to be a payout, and there's a formula for that as well. If it's a 401k, it's easy. It gets divided usually as of the date of the commencement of the divorce action. And there may be some separate property. So you want to, if you want to identify if there was a 401k prior to the marriage and then it got rolled in, and you've got to trace it. And so there's a lot of pieces to this. But all of those assets that you mentioned are certainly discoverable and can be valued and are important. Now, you did mention one other thing, which is maybe you invested in a company and you did a small investment. Maybe it was like an angel investment. A lot of the times we don't value those investments because it's so expensive to value those investments, and you might have a fractional piece of them, right? So what we say is let's divide them in kind. So let's just say you have 2 shares of something. Each one of you might get one of the shares. And maybe it can't be transferred to the other person because the company doesn't want to be bothered, frankly, that you've invested in. So maybe you'll hold it as a constructive trust. And when you get distributions, you turn over the monies, and we put that all together in an agreement.
Yeah, I think that is an excellent way to look at that, or to kind of summarize that you should be aware that some of these are issues. And if you have to deal with it, sometimes, like if you've invested $50,000 for 2 shares, we can also say, like, can we agree that you put some marital money in it and it's worth that? Because I will have spouses that both believe that the business could hit and would still want to have some, would be in it. Well, I don't want to take the 25,000 because I really think it's going to be worth something. So we've seen that. Now, the only thing that it made me think of that we didn't quite talk about, which maybe wraps up into the percentage of the business, is the personal goodwill. Like, do you guys get involved with personal goodwill? Because that would actually typically be handled at like the valuation level. But
Yeah, so it's not really in New York. I mean, we don't really. It's all part of that business valuation, but we don't really. Not as a separate asset.
Okay, so it feels like it kind of comes into play with that percentage that could be under 50. Okay, so that makes sense. Before we get into all of the amazing things about you, I wanted to just ask a simple question. A lot of people do want to figure out if they can file on their own, or maybe they have a super simple divorce and they're like, I don't have a business, I don't have all these things, but it's very difficult to fill out, those forms for New York. What are some of the things that you should just kind of avoid then? Like, maybe are there some big potholes that you should avoid if you want to try to file for yourself? Is that a better question? Or maybe suggestions for what to be mindful of if you decide to file pro se?
So I would say things that you need to be mindful of are important deadlines. So you filed your summons and you have 120 days to serve it, or it's not valid. Okay. There's a bunch of those kind of deadlines that you need to be aware of. You also should be careful in terms of how you're filing the documents. When you actually come to your divorce agreement, make sure that you've accounted for all the assets. Make sure you've accounted for the personal property, because maybe you forgot some of these things. That should all be in the agreement. And then you're going to have a series of documents that are required in order to get your actual divorce, like a judgment of divorce, findings of fact affidavits, removal of barriers for remarriage, etc. And you should find out what the filing requirements are in the courthouse that you're going to file in, so that you get the documents right and they don't get bounced back to you.
Okay. And then can you file like online? Is there a process, or are you filing with the court system still?
So usually if you're doing it yourselves, then you're going to go down to the county clerk and find out what that particular county clerk is going to be looking for. And I would say it's important to go in person. There's usually a pro se litigant office in the
Okay.
courthouse where somebody will possibly walk you through some of your questions. And so if you're determined to do this, then that may be the way to do it. The other thing is, if you're going to do it, you might want to work, if the two of you are going to decide that you're going to proceed pro se, each of you, you might work with a mediator who's local. If there's, not a lot of assets to be valued, not a lot of income, you might work with a mediator and go through it, because that mediator might help you with the divorce documents too.
Is the state of New York requiring any mediation hours before you go into? Okay.
No.
Are you seeing mediation be successful in helping some business owners even through the system, or?
I think mediation sometimes can be helpful. I have to say, if you're a business owner or there's a business involved, I would say that mediation can be difficult at times. And the reason is that there's a lot to know, right? And mediators don't necessarily have some of the authority to, for example, they can't just serve subpoenas. And you're relying on the goodwill, right, of the titled spouse to be honest about a lot of things, right? And so I would say that if there was a business involved, I would probably want to have an attorney on both sides.
Yeah, gotcha. And then one final question. What are some unique state statutes or divorce cases that you have to follow in New York because you stated one already, you don't have to say it again, but I just think it's interesting because most states, we follow different states, different statutes, different cases, and, just even an example or something that is a unique one that maybe people would stumble upon if and it could kind of harm them if they weren't aware of it or something, or just a unique, interesting, like we have some that, because we're in the Midwest, that are just kind of ancient and interesting. So I thought it would be unique for some of our viewers.
So look, I think that there's so many cases out there in New York. I'm going to say that, right? And we read the appellate division cases very closely. And so there are always unique cases out there. I think one thing that's starting to come up, frankly, is, and I don't know that it's unique necessarily to New York, but the fact that you can now, and it's an interesting situation, you can now contract for what is going to happen in terms of embryos that are created through IVF. What happens to those embryos in terms of distributing them in the event of a divorce? And so you can contract for that in a prenup. Now, in a prenup in New York, you cannot contract for about custody, and unless there is a child born, and you cannot contract for child support unless there's a child born. Okay. And so that may be unique to New York. And the other thing is, obviously, equitable distribution is, it's certainly not, we're not the only state that has equitable distribution, but as you probably know, Melissa, there are a lot of states that have community property and everything is just split, basically, right? And New York is not like that. You have to actually show contribution.
Well, and I think it's important to understand that community property states may have some, simplicity to them, but and I'm also in Missouri and an equitable distribution state as well. That's why there's some complexity if you're a business owner, is just that, there are some things that are there in place to protect you and give you some credit for more of that business, but you have to go through those loopholes to prove it and to support those conclusions. And it's a legal and financial thing. Like that percentage is being based as a legal thing on top of the financial, which is the business valuation. So I think it's just it's being aware, it's being understanding what is out there. And I think that you've given us a tremendous amount of information. I want to just give more information about you because you do have a very unique background being an attorney and a CDFA. And I do see actually some attorneys going into mediation and getting CDFA or LLM and all of these things because we're doing a lot of financial within the legal construct. So maybe tell us a little bit more about your background and why somebody would reach out to you in New York.
So I think the first thing is, this is my second career. And that is a little bit unique for attorneys to have a second career. I didn't start out in law. I started out in the fashion business, and I went through my own divorce, and then decided to go and get my bachelor's degree and then my law degree. And I was very focused on going into matrimonial law at that point because I had gone through my own divorce and I felt like I could be really helpful to people. I also had the experience of negotiating. And so I think of myself as a strong negotiator because I was negotiating markdown money, with major retailers across the country. And I was negotiating returns and, all those things that come with being in the fashion business. And so I think that I have a unique background. I also, as you said, I did get my CDFA, which helps in terms of understanding some of the finances. And I'm a certified financial litigator, which means that I went through the certification and the coursework to understand finances, in a better way. And so those are all the reasons. I feel comfortable in the courtroom. I feel comfortable at the negotiating table. And I am a strong advocate, I believe, for people. And so I think that is the reason that people come to me.
Yeah. And I think that, I definitely have an opinion about financial matters and lawyers kind of staying in the legal side and financial people staying in the financial side. And I think that it's always beneficial if you have both sides, even as a financial person, I need to know what happens in litigation, or else I can't really talk about it in mediation either. I have to have that reference point. But I think that I would encourage people to seek out an attorney that has an understanding of the financials, because I've worked with a lot of attorneys for a long time. And if you don't like it or you don't get it, you're never going to. And, I've worked with attorneys that I've explained the same thing to them for decades. And they're still like, could you tell me what a cap rate is one more time? And I'm like, sure, no problem. But, math isn't easy for everyone. So if you have somebody that understands the legal and the finances, they kind of know when to bring in the expert at better times. And I don't know if you can talk toward, or it's sort of like, the bookends, like don't go too far, but we do have a problem here kind of situation, right?
That's so true. And, I look at it a lot in terms of tax issues, right? So I can identify the tax issue, but I'm not going to resolve the tax issue, right? I'm going to make sure that I've called the accountant or the forensic accounting firm or whatever it is, right? And I'm going to make sure that we completely understand the tax issue and that we also make sure that the language in any agreement is correct. And I'm going to review it with an accounting firm because I am not going to take that leap as to what that tax language should look like. And I think that it's really important that you have an attorney who can identify the issues, but also understands, as you said, not to go too far. You may need an estates and trusts attorney. You may need tax counsel. You should have an attorney who can, a matrimonial attorney who can identify what those issues are. Look, I just did a very complex deal, and I really mandated that we have all of the professionals, tax counsels, trust and estates counsel. And I remember the other side saying, oh, we don't really need that. And I said, oh, no. We are going to have all of that. We are not going to not have that. And in fact, it's really not so much about you and it's even not about the clients. It's about me. Okay. Yeah. And I am not going to make a mistake in somebody's agreement that is going to cost them a situation, because that's my reputation on the line. Yeah. And I want to make sure that we have dotted all those I's and crossed all those T's. And you need to make sure you have the professional who is in there. And by the time we were done, I'm going to tell you that the other side was looking for their tax counsel and their trust and estates counsel, because they realized that it was so complex. And they said to me, you were right. Actually, we did need all of these components. So
right. And it's not from a fear base, but there are certain things that you can do that could be really not good in the entire situation. Like if you think there is fraud in the IRS and the tax returns, to go and self-report and then get hit with, $1 million of that's probably that was a good bluff. Good move on you, but harmed everybody in the process. And I think that, to me, a red flag in an attorney is somebody who's not willing to understand that we make a better team when we get the right players. And for the most part, I think that if you're with a right attorney, they're going to know, hey, I got a great person that does this. I got a great person that does that. And they're going to bring in these people that they know understand the divorce world, because it is a little bit different. It's not, like what's happening in New York is different than Missouri. It's different than New Jersey. It's different than right across, and I think that business owners have to understand that, especially if they're filing and they're picking, like where they're married and where their business is and where all of these things. And they're like, oh, well, my business is over in this state, but I'm married over in this state. And, they're thinking federal laws. They're thinking, that this isn't a state specific thing. So I think, I appreciate you, Lisa. And if there's anything else that you want to kind of, have people understand how they could reach out to you, we've given some contact information, including your email. I don't know if you typically do, intake or intro sessions and things like that. I usually advise people to at least talk to somebody who has a lot more capabilities than just to charge through to court. But are you also trained as a mediator, or have you done mediations?
So I am not trained as a mediator. And by the way, many
Does
mediators
it
are
really
not trained.
matter?
I was just going to say they're not trained as mediators either. So
Right.
I think that, we in New York, we have therapists who are mediators. We have a whole bunch of types of people who are
Yeah.
mediators,
Yeah.
and they haven't been trained in it. And that actually becomes, somewhat difficult. So I will say that having a consultation with an attorney who is a skilled attorney is really important, so that you can understand. We do a full consultation. We do charge for it,
Okay.
but we do a full consultation, and we really lay out all of the pieces for someone, so that by the time they walk out or they get off the Zoom, they really understand what the scope is, and the good and the bad. Frankly, you need to make sure you find an attorney who's going to be honest with you. That's, I think, the most important thing. So many people come to me and they say, well, I was told this or that. And we're very honest, because I want people to feel that they really understand what is going to happen, and that there's no surprises, or certainly less surprises than could be.
Right. And for right now, I mean, you've basically provided an hour consultation to a business owner and the big things that they would deal with. So, meeting with you and paying to meet with an attorney at the beginning is very rational. It is, really sitting down, making sure that you're sure about it, asking the right questions, making sure you have a plan, and then executing on the plan. That's how you go through divorce in a more efficient manner. If you want to just like show up for the consultation and like wing it, okay, that's fine. But, you have to figure out what participation level you are in this divorce, whether you can handle doing it on your own and negotiating, or what level of the spectrum you're on that you need somebody to do it for you. And wherever you are on that spectrum is how you figure out, what you need to do to go forward. So we appreciate all this information. Thank you so much, Lisa. I'm sure we'll have you back, because there's a couple areas that I think we could go a lot more deeper.
Thanks so much.
So appreciate it.